persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Thank you. All righty. Good afternoon. Welcome to another oral argument session of the 5th District Court of Appeal here in Daytona Beach. For our record, it is Thursday, March 16, 2023. I had a full docket this morning, and we have one case on the docket this afternoon. It's case number 21-3196, Florida Farm Bureau General Insurance Company versus John Worrell and Joyce Worrell. Couple things. Each side will have 20 minutes. Appellant, we will set aside, or I'll set aside 5 minutes for rebuttal. If you want a different amount of time, let me know, and I'll adjust the clock accordingly. When you get into your rebuttal time, you will see the yellow light going on. If you want to continue on, that's fine, but your aggregate total for both your initial and your rebuttal argument is 20 minutes. Let me introduce the panel. To my right, your left, is Judge Harvey J., who is one of our new members to the court coming from the first DCA, and to my left and your right is Judge Adrian Soud, who is also another new member. He's a former circuit judge in Jacksonville, and so he joined our court on January 1 as part of the realignment process to get Jacksonville judges on our court. He's the guy. How about that? If you happen to have a cell phone or any other electronic device on, please either put it in mute or turn it off so it does not inadvertently go off during the course of your argument and interfere with either you or your opposing counsel's argument or the court. That being said, I can't think of anything else more to introduce about or talk about, so why don't we get into it. Ms. Klein, whenever you're ready, ma'am, you can proceed.
Thank you. Hinda Klein here on behalf of Florida Farm Bureau. And before I begin, I wish to thank the court for accommodating me. I originally had back-to-back oral arguments on Tuesday, and the court graciously permitted me to move one of them. So thank you.
You're quite welcome.
The issue before the court is fairly narrow, and that is whether the trial court erred in granting the Worrell's motion for summary judgment and denying Farm Bureau's motion on the issue of whether the pollution exclusion in its policy excluded coverage for damage caused by an individual's blood.
We're in a kind of unique scenario. I mean, this is de novo review. It's insurance contract interpretation on a summary judgment. Plus, apparently, everybody seems to agree there's no other case law in the country that deals with whether blood falls under this exclusion. So contextually, the reasoning by the trial court doesn't really matter to us, does it? The question before us is, and based upon Mr. Nation's brief, the question really before us is blood come under the exclusion?
Correct.
I mean, and following up that, if feces is in fact exclusive, is excluded under the pollution exclusion, we still go forward. You don't win on that because
There's
of the
no
concurrent cause
correct.
right under SEBA. All right, go ahead.
So really the focus is on the blood as opposed to the feces, which I think both counsel agree is...
Sounds like waste to me, but go ahead.
Well, and explain that to me, Ms. Klein, and Judge Lambert, quicker on the draw than I am this afternoon. But so we all agree feces would be excluded. Is there no way to portion it out? Is it not like a claim in the lower court where if you can't differentiate, you pay for all of it or you don't pay for any of it? Or is that not the algorithm here?
Well, the problem is, of course, as far as Farm Bureau is concerned, it was cleaned up long before, we were involved. So, what precisely was cleaned up is still in question, but the police report indicates the presence of what appears to be feces and blood. And I don't really believe that there is a question as to whether there was actually blood there.
So, and let me follow up with that if I may. So if we were to find, I'm not suggesting we would, that feces absolutely would be categorically within the exclusion and not covered. Blood would not be excluded. You lose, your client loses under that scenario?
Well, my trial counsel didn't really raise that as an issue of fact before the court. Both parties posed it as a question of law. So I believe that in light of the language of the policy, where there was no anti-concurrent cause provision relative to the pollution exclusion, we would necessarily be on the hook under those circumstances.
So back to my initial question, as far as differentiating between the two, that ship has sailed.
That would be correct, yes.
Thank you, Ms. Klein.
I don't think that there's any dispute here that the pollution exclusion has been held by the Florida Supreme Court to be clear and unambiguous, even though there is no definition in the exclusion as to the terms irritant, contaminant, or, for that matter, waste.
And it's your burden as the insurer to prove that the exclusion applies in this all-risk policy, right?
Correct, but it would be, frankly, under any policy.
And do we construe the exclusions narrowly? I mean, if it's ambiguous, I know it's been held not to be, but it's ambiguous, we construe more favorably towards there being coverage. If we're construing an exclusion like we are in this one, in this case here, do we construe that narrowly? In other words, not favorably towards your side?
No, I think actually the court could construe it broadly under the circumstances because of the broad nature of the language itself. As we pointed out, the vast majority of cases that have dealt with this pollution exclusion have not only found it not to be ambiguous, but have applied it in all kinds of circumstances, whether it be fecal matter, backed up sewage. I believe there was a case involving a swimming pool where a pool man pleasured himself. There have been all kinds of applications to this pollution
That would seem to be your
exclusion.
best case, Chestnut, isn't it? That's
Excuse
a
me?
bodily fluid, much
It's a
like blood is
bodily-
a bodily fluid.
Correct,
So-
and I don't see how a court could find that to be a bodily fluid excluded from coverage under the policy, but not find blood also excluded. It seems to me that that sort of opened the door to any kind of bodily fluid.
Well, Judge Evander, before he left, he wrote that opinion in Vasquez that was cited that, you have to read a policy as a whole and afford words their plain meaning as bargained for by the parties. So, I guess that's binding on us because he was just here and he wrote it. So, so the plain, taking what he wrote in Vasquez, we would have to say, is the plain meaning or plain language of blood a pollutant, which is defined under the policy as an irritant or a contaminant or waste. So tell me how the plain language of blood translates to a pollutant.
Well, I think that it really relates primarily to the term waste as used in the context of the pollution exclusion. Most of the cases that have found that bodily fluids are excluded have focused in on that particular term, and waste is clearly encompasses both blood and fecal matter. There can't be any legitimate question that
Is there any other word in this exclusion or the provision of exclusion that could apply to biological or medical substances?
Well, irritant or contaminant both of which would apply under the circumstances, but waste, I think, is by far the clearest because it is something that is extruded from the body and wasted, if you will.
This resulted from a trespass onto the Worrell's property, did it not?
It did.
Does the policy cover the trespass? In other words, is the trespass the event that's at issue? Or is it the existence of a bodily fluid or a bodily excrement that's at issue in the particular provision?
The bodily fluid excrement. I don't think there's any dispute on covering.
So if the person who trespassed onto the Worrell's property goes into wherever he was in a particular location, falls faint and falls into an object that damages the drywall, let's say hypothetically. Covered?
That would be covered.
If the same individual is trespassing in whatever part of the location, is stealing a lawnmower, and he just so happens to kick over a can of gasoline, covered?
Yes.
But isn't gasoline a contaminant?
Well, actually, I believe so.
So is it your client's position that just because the consequence of the occurrence, the consequence of the trespass, happened to be biomedical type substances left, that shields USAA from having, or the insurance company from having to cover?
Yes, because the question is what allegedly damaged the property, and the damage was caused by the bodily fluids.
So should the court view and interpret the language of this provision and look at the term waste by the company it keeps?
No. I think the case law on that has also been pretty consistent in finding that just because it says including recycled, reclaimed, etc., that does not limit it, nor is it limited by virtue of the fact that the pollution exclusion also talks in terms of industrial kinds of dispersals, discharge, etc. I think all of the cases that have dealt with that have said that.
So are we obligated to look at the exclusion provision and consider what an ordinary person would reasonably understand the provision to provide?
No, under the doctrine of reasonable expectations, that doctrine has been specifically rejected by the Florida Supreme Court in the Denny case, and the court also happened to notice that in those jurisdictions that have adopted the reasonable expectations test, they have only done so where there was a legitimate ambiguity. And since the Supreme Court has already found that this is clear and unambiguous, there wouldn't be an opportunity to apply the reasonable
So
expectations
following
test.
up on that, do you believe that the Denny case, the Supreme Court case, has implicitly overruled this court's 1997 opinion in Mason, where we applied the, quote, man-on-the-street analysis to read the language and interpret the language of the policy with its everyday meaning as understood by the common person?
Yes, I do. I believe that this court found that, I think that's the Burge case, and I believe the court found there to be an ambiguity in the pollution exclusion, and more importantly, actually, I believe that the language of that exclusion in that case was actually different.
It was, and this
Yeah.
actually is and this wasn't talking about the pollution, but this is where the man-on-the-street
Oh.
analysis came in, saying, kind of following up what Judge Stout is saying, is do we read it like everyday people, or do we read it like a bunch of appellate lawyers and judges, or whatever?
I believe that I
If you
think-
want to read it like an appellate lawyer, and you hope we act like appellate judges for a change here, but...
But yes, it's not about what the man on the street would understand. I mean, the man on the street looking at a pollution exclusion would not immediately say to themselves, oh, that excludes fecal matter, or,
Or blood.
or semen, or anything else.
Fecal matter makes more sense. That's waste. I mean, that's human waste. So
Right,
people think
right.
that and say, all right, that, yeah.
But yes.
And I want to ask about waste, but before I get there, you answered Judge Sal's question. I think he was referencing Nosquiter Socius, which is a word that's known by the company it keeps, but you would say that concept would not apply here because of the lead-in with including. So let's assume we don't apply it. But what do you do with Mr. Nation's argument? It seems fairly compelling that you have a tree that falls in the backyard, maybe falls on the house, but once the tree falls, it's waste. And would that be excluded by the policy?
Well, again, it would come down to what caused the damage to the house. If the damage to the house was caused by the tree falling on it, and as part of the ensuing loss, there was some kind of, I don't know, bug infestation or what have you.
And I get that.
Yeah.
But I'm saying, what I heard him saying, I think, is that becomes yard waste, so why couldn't you argue, well, the tree fell in the house and now it's yard waste, so that's excluded, even though it went through my bedroom window? I
Well,
mean, what do you say to that?
Well-
This is such a broad term.
I think it has to be waste at the time that it damages the property. The fact that it may ultimately become yard waste, I think would be irrelevant to whether it was covered as it happened.
So it was a tree when it hit, and it was waste when it hit the ground.
Yeah, what about that?
I mean, that sounds
Well,
like what you're
it-
saying. It
it-
wasn't waste when it came down and hit the house, but once it's laying on the ground and just hanging out, because nobody's picking it up, then it becomes yard waste.
Well, but it was a tree when it hit the...
So that, I guess you'd say that's covered, but once it's laying on the ground, if it does anything else, then it's not covered, whatever it does when it's on the ground.
Correct. Correct.
Well, absent the Chestnut case that one of our Middle District of Florida judges wrote, that ejaculate is, I mean, I guess that would be, I guess if somebody was pouring blood into the pool, I guess that would be analogous, but absent, let's say that case that the judge had stopped in that opinion, because that was like the last thing that she wrote in her opinion as to why this was not a covered event, when she could have decided that it was masturbating was outside the scope of the guy's duties as a pool cleaner, which didn't seem like a big leap, but that being said, so she wrote that. But if that wasn't there, what would be your best case after Chestnut? Because it seems to me Chestnut is the best case that Mr. Nation probably needs to talk to us about as to why that's not analogous.
Well, I think the Hirshhorn case, but that is a Wisconsin case, but otherwise then under Florida law, the WPC and Industries case, and Philadelphia indemnity versus Yachtsman, both of which
But
dealt with raw sewage.
Yeah, that's feces and raw sewage. I mean, that makes more, yeah, okay, that's waste, that's garbage. That, raw sewage comes into my yard, we're not insuring for raw sewage, that's waste. Nobody really equates that with blood. I mean, I know you dispose of needles, whatever, when you're the doctors, and they consider that waste, but I mean, and I know we don't want to talk about the man on the street, or the woman, or the person on the street, I'll be politically correct for a change. I'm having the other cases that you cite in your brief that support your position make logical sense to me, which is a nice thing to happen when judges write things that they actually have some logic to them. But yeah, the leap into the ejaculate in the blood is the tougher leap, and I mean, absent Chestnut, there doesn't seem to be a lot of similar type of liquid type of product that comes into the pollution world other than what we think of traditionally pollution from the 60s and 70s, which I understand we're past all that. But I was just curious if there's any...
Well, how do you clean it up? In this case, you have to get somebody who is experienced in biohazards, which is exactly what Accident Cleaners and Restoration does. They didn't call Stanley Steamer to wipe up blood. They called a biohazard company. And I think that speaks volumes as to whether or not this is an irritant or contaminant or even waste.
Let me just, you're 4 minutes left on your rebuttal. You can use as much time as you want. But.
I was just going to say that I don't see any legitimate distinction between blood and any other kind of bodily fluids. And I think that the weight of authority is clearly in favor of a broad reading of the absolute pollution exclusion, and I would request that the court reverse the summary judgment in favor of the Worrells, and I'll reserve on the rest of my time. Thank you.
All right. Thank you, counsel. All right, Mr. Nation.
Good afternoon, everybody. Thank you, counsel. The constituent elements of blood: white blood cells, red blood cells, plasma, and platelets, none of which as a whole or individually are a contaminant or an irritant or a waste, not even close. The reason that the Denny case said there was no ambiguity is because they were talking about ammonia and pesticides. But when those squarely fit in the exclusion. But when you get on the ragged edges of the exclusion, Burge, they said feces, it's ambiguous as to feces. Here, we're not even close to the edge. It doesn't fit at all. Blood doesn't fit.
Are you conceding feces then?
No, because Burge says it's not. Burge says it is not a contaminant. It is slightly different language. They don't have the word waste in Burge, so I think that's probably where y'all are going. But if we look at waste here, well, let me address that. Even if feces was a pollutant, it's not excluded because we don't have any, we have no anti-concurring clause. It's covered. The whole thing's covered under CBUG. If one thing's covered, one thing's excluded, the whole thing's covered. If they had anti-concurring cause language, then we'd be looking at a factual issue. Can the jury parse it out?
Much like what Judge Jay was talking about earlier.
Absolutely. But blood's not even close to the ragged edge of this exclusion. It's way outside. And if we look at the exclusion, I went through it and I put every word in order, crossed off the ones that don't work. The only one they have is waste. And words are known by the company they keep. If I say, I want dessert, and somebody says ice cream, here's cake, good, that's it. But here's a raw steak, it's unambiguous. Dessert is unambiguous.
Do we look at the definitions in dictionaries as to what an irritant is or contaminant or waste to help us make our de novo determination as to whether blood is a pollutant?
You can go there, but I would start with couch and ALRs. And it doesn't get you anywhere close. And as to the distinction between reasonable expectation and reasonable understanding, those are two very different things. We don't follow the reasonable expectation test. What would somebody expect it to cover? But we do follow reasonable understanding of the words. The man on the street, how would they understand the words that are being used?
I think I heard you say, Mr. Nation, I don't want to misquote you, I want to give you a chance to answer rightly, but is it your opinion, your client's position, that these words are unambiguous, and because they're unambiguous, your client wins?
You are correct.
And the reason I say that, and I did a jet tour through some of the federal cases before we got here today, and that Mosquito Associates, a word is known by a company it keeps, there are certain federal appellate courts that say you never even get to that rule of interpretation if it's unambiguous. So that's the disconnect I'm having. If it's unambiguous, we just read it the way it is, and that's what you're asking us to do.
Now, here's what I'm saying. Unambiguously, I believe blood falls outside this exclusion. It's not ambiguous. If you were to say their argument is reasonable, it would simply be a reasonable one. And at that point, you would resort to certain tools, but the tool would be it's an ambiguity, and as Vasquez says, it's got to be interpreted in our favor. The rules of narrow interpretation of exclusion, though, don't have anything to do with ambiguity. I know that's not exactly what you were asking, but I wanted to make sure we're clear about this. And this is 5 DCA, FCCI versus Horn. In construing insurance contracts, the courts generally apply liberal interpretation to coverage. Exclusions are interpreted narrowly. Then it goes on and says, in addition, if any ambiguity is found, it's to be construed against the insurer. So the narrow interpretation of exclusion is not a tool in our toolbox for ambiguity. It is a tool before we ever get to ambiguity. And all exclusions have to be interpreted narrowly, not just if there's an ambiguity. And we also have with the 5th, I can't even pronounce it, HRYNKIW versus Allstate, exclusion clauses contained in a policy issued are generally considered contrary to the fundamental protective purposes of insurance. Thus, the courts give a strict interpretation to exclusions as opposed to liberal involving coverage.
I sense some of your frustrations with the Denny opinion that does make the statement that this pollution exclusion clause is unambiguous, but applying it to the facts of that case is clear why it's unambiguous. But when we're talking about blood, that seems to beg, like, it is ambiguous as to why blood would be considered a pollutant, and if it is ambiguous, then obviously we would construe it, more strict against the insurer and in favor of coverage. But we're bound by what the Supreme Court tells us.
You are, and I'm fine with that, because in the context of that case, it was unambiguous, and that's all it was talking about.
Well, let's talk about Chestnut then, because that seems as unique in its facts to apply ejaculate to a pollution exclusion under a homeowner's policy, or I guess that was a...
Yeah, it was a liability policy,
Liability.
liability. When I read it, here's what I thought. Bad facts make bad law. That's just an odd fact pattern. The district court judge found what he found, no coverage, case went away. Maybe it's results-oriented, I don't know.
Well, it was interesting, because it looked like it could have been disposed of without even touching that exclusion, but
Yeah,
to find no coverage, I mean,
right, an intentional act.
intentional act, outside scope, and then they said, oh, by the way, let's talk about the pollution exclusion on page 8 of 9, and they added a couple paragraphs and reached the conclusion, which certainly is favorable to Florida Farm Bureau today, that
It
analogy
is. It
Say
is.
bodily fluid,
It has bad facts, bad law, doesn't have anything to do with the blood here. This is an all-risk homeowners policy. That was a liability policy. The tort that was asserted there was intentional infliction of emotional distress. Just not our situation at all. I don't know what component of the blood would be an irritant or a waste, and its waste includes, all right, let's look at what they're talking about. Materials to be recycled, reconditioned, or reclaimed. There is no way they were talking about blood. And to the extent that they wanted to exclude it, Burge came out, when was it, 1994? This insurance company knew at that point that sewage, raw sewage, did not constitute a contaminant. If they wanted to expand it to bodily fluids, they could have said so easily. What is in a home? The most common thing inside of a home is a person. People die in homes. People cut themselves. Are they saying if you cut yourself in your kitchen, you've got blood in the grout, they're not going to clean it because it's contaminated? It makes no sense.
what about their argument that blood falls under the biomedical waste definition in 403.7033?
Yeah. So we have a whole body of law that deals with the disposal of biomedical waste, chapters in our statutes. They know people die at houses. They know they get hurt at houses. People get shot at houses. Are they saying the blood, the tissue, the organs, all of that, muscle is a waste? It makes no sense at all. And if it is so prevalent that we need an entire section, a body of law on it to define it and what to do with it, they ought to put it in their policy. In their policy, they
They're saying
don't.
they don't need to because it's an unambiguous provision.
Yeah, for ammonia and pesticides, I agree. But as you get to the edge of that exclusion and try to fit things into it that don't apply, there is a point where it is ambiguous. Feces under the Burge case. I think blood is outside of it, but if this court were to say, you know what, they have given a reasonable interpretation, that's fine. I don't know that anybody can say our side's interpretation is unreasonable. It is certainly a reasonable interpretation. It's got to be interpreted in favor of the insured. So I'm going to check my notes if you all have any questions. I told counsel on the way over here I was going to stop at Publix and buy some blood sausage. I thought it was funny.
Be contaminating our court, or at least irritating Judge Jay.
And I will check. I think that's it, gentlemen. Thank you. Appreciate it.
Counsel, thank you.
I believe there was a question as to whether or not the opposing counsel conceded that feces would be included within the pollution exclusion. It was, at the hearing, it was conceded at pages 533 and 534. Despite that concession, the court did lump it in with the blood, but I did want to bring that to the court's attention.
Meaning it was conceded at the hearing that feces would be excluded.
Correct.
The Florida legislature uses biomedical waste or biologic waste in section 403.703, and those are terms readily utilized in other contexts. Does that have any bearing whatsoever in your analysis as to how we define waste here?
Well, waste is not limited to industrial or environmental causes. So the terms used in Section 403, which do address biological and biomedical waste, I think is a legitimate source for the court to look at to determine whether or not the term waste is used in the pollution exclusion would incorporate that or could incorporate that. And I think under the circumstances, in light of the fact that we do have this statute coupled with the authority from, granted, the lower federal courts, I think the only rational conclusion is that blood, like fecal matter, is some kind of biomedical waste, and as such, it should be deemed to be within the pollution exclusion. And I would also point out, opposing counsel relied very heavily in his brief on the justum generis line of cases, but that was specifically rejected by the Supreme Court in the Denny case as a limitation on the application of the pollution exclusion. It was likewise rejected by the California court in Ortega Rock and the court in the Hirshhorn case. So I think that argument has already been soundly rejected by the vast majority of the courts. There is no such limitation when you read the pollution exclusion. And I would respectfully request that this court reverse the summary judgment in the Worrell's favor and remand for entry of a summary judgment in favor of Farm Bureau. Thank you very much.
Thank you, counsel.
Thank you.
Well argued by everybody. All right. We will stand adjourned and take it under advisement.